Collision actions are not very common. Appeals to the Supreme Court on collision cases are exceedingly rare, and the Supreme Court has just handed down judgment in the Eversmart, and Alexandra won the first collision case to be dealt with by the Supreme Appellate Court since the Savina in 1976. And it's a case of considerable importance, both for the application of the collision regulations in general, and also in particular of an explanation of how the crossing rules in the collision regulations work, both generally and in the context of the narrow channel rule. The facts in a nutshell were these. The outbound Eversmart, a large container ship, was proceeding in the channel at the port of Jebel Ali towards the exit of the channel. The channel exits in a pilot boarding area. Another vessel, the VLCC Alexandra 1, was effectively drifting at no more than a knot to 2 knots across the mouth of the channel, waiting for a pilot, the pilot on board the Eversmart, to be passed over to her. A collision took place. Before the Admiralty Judge, Mr Justice Teare, it was argued by the Alexandra 1 that the crossing rules had no application to her. The Eversmart had argued that the Alexandra 1 was a crossing vessel and therefore had to give way to the Eversmart as the Eversmart came out of the channel. The Alexandra 1 disputed that for 2 reasons. Firstly, it said that the crossing rules have no application in the vicinity of the mouth of a narrow channel. Only the narrow channel rules apply, or Rule 2, the general rule of good seamanship. Secondly, they said that the Alexandra 1, because she was drifting on a slightly varying course at a very low speed, was not on a sufficiently steady course, and the crossing rules only applied to the putative give-way vessel if the vessel was on a steady course. As I said, Mr Justice Teare, the Admiralty Judge, found for the Alexandra 1 on those arguments and apportioned liability on the basis that the crossing rules did not apply to her, and therefore the only rules that were applicable were the narrow channel rule and Rule 2. Liability was apportioned 80% to the Eversmart and 20% to the Alexandra 1. The matter went to the Court of Appeal, where the Court of Appeal, with the lead judgment given by Lord Justice Gross, upheld the views of the Admiralty Judge and expanded on the reasons why the crossing rules did not apply. The Eversmart appealed to the Supreme Court, and I had the privilege of arguing the appeal for the Eversmart, and the Supreme Court overturned both the first instance and Court of Appeal judgments and held that the crossing rules did apply. The judgment is extremely interesting. Not only, it's very long, 94 pages, not only for what it says about the 2 issues, which I'll come on to in just a moment, but also for a general analysis of the collision regulations and how they are regulations which must be viewed and construed as applicable to, as the court put it, mariners of all nationalities, of all types, professional and amateur, in a wide range of vessels and in worldwide waters. And what the Supreme Court did, which was novel, was to test a lot of the arguments by reference to how smaller vessels, either with or without radar and ARPA, might have to apply the same rules. Taking the issues in turn as the Supreme Court dealt with them. First of all, does the give-way vessel have to be on a steady course? The court held that that was a completely inappropriate analysis. The 2 crossing vessels may be approaching each other and remain on a steady bearing, even if they are not on a steady course. The court took a practical test of looking at vessels which are moving so as to cross, involving a risk of collision, and held that the crossing rules did not depend upon the vessels being on a sufficiently steady course. And indeed, even if a vessel was on an erratic course, she could still be on a course which was shaping her to cross with another vessel. That was all that the crossing rules were designed to capture. Secondly, in relation to the application of the crossing rules in the vicinity of a narrow channel. The textbooks, Marsden on collisions, and other textbooks have considered that there is an area of doubt as to how these rules are to interact. Rule 9, the narrow channel rule, and Rule 15, the crossing rule. The Supreme Court analysed the position not only for the facts of this particular case, but as it said, to determine with clarity and as precisely as possible the circumstances in which these two sets of rules either would apply together or one would apply displacing the other. And the court identified three broad groups of cases. One, group one, which are vessels which are simply crossing across the channel from A to B without intending to enter the channel in any way. The crossing rules plainly applied. It did not matter that they were crossing in the vicinity of the narrow channel. Secondly, group two were vessels which are intending to enter the channel and were on their final approach to the channel and were shaping their course to enter the channel. Cases such as the Kaiser Wilhelm de Gorsa and Kullermessin and HKASR. In those circumstances, the court held that the crossing rules were disapplied, and the only rules that applied, because effectively the vessel was already on a narrow channel route, although she was still outside it, were the narrow channel rules. And then the situation in which the Alexandra I found herself, a vessel which is tracking across the channel, at the mouth of the channel, but effectively waiting to enter the channel in some way, waiting for a pilot or waiting for the channel to become clear. In those circumstances, the court held that the crossing rules did also apply. The judgment is a model of clarity and is extremely useful, as I've said, for the wider aspects, helpful definitions of heading, course, and bearing, as those terms are used in the collision regulations, a close analysis of how the collision regulations are to be construed, in particular, the importance that the crossing rules are to have, and how the crossing rules are to be construed as applying wherever applicable, even if one needs to resolve conflicts by moulding the standard of compliance with those rules. And the dictum of Lord Wright in the Alcoa Rambler 1949, that the crossing rules should apply wherever possible because they tend to secure safe navigation, was rigorously endorsed. An interesting and important decision, and one that re-emphasizes safety in navigation, which some commentators felt that the decision of the Admiralty Judge and the Court of Appeal failed to do. Thank you very much.